Mr. Henri van Breda seeks relief to the Supreme Court of Appeal against his convictions and sentences. The test for such applications is set out in Section 17 of the Superior Court Act, Act 10 of 2013. The applicant's counsel, Mr. P. Botha, has not advanced any compelling reason why the appeal should be heard. Instead, relying upon Section 17, 1A, subsection 1 of the aforementioned Act, he argued that the appeal would have a reasonable prospect of success. The latter conclusion is premised upon the argument that this court erred or misdirected itself in finding that the proven facts are only consistent with the appellant's guilt, or, put differently, that the proven facts exclude a reasonable inference that the appellant was not the person who attacked his family. Mr. Botha set out in some detail the facts which he says support his case. The arguments advanced by him are similar, if not the same, as were advanced by him during the trial. These contentions were carefully considered and rejected in the principal judgment, and I do not propose reiterating them herein. The evidence establishes conclusively that the applicant was the party responsible for the commission of these offences. The objective facts support that conclusion, and there is no room for any real doubt. The key pillars of the state's case against the applicant provide conclusive evidence of his guilt and are, in effect, unassailable. With regard to the sentences imposed, little has been said to suggest with some degree of conviction that another court would differ. In the light of the heinous nature of the offences committed by the applicant, and in the absence of any other significant mitigating factors other than his youthfulness and lack of previous convictions, any lesser sentence or lesser sentences would not have been consistent with our sentencing regime. In the result, the application for leave to appeal, both against the convictions and the sentences, is refused. Hopefully that's my last word on this case. This court is adjourned.